So today we're going to discuss what is maximum medical improvement, MMI, in your workers' compensation case, and how long does it take to reach MMI? Workers' comp, as you guys know, is very acronym driven. We have an acronym for everything. So MMI is maximum medical improvement. Maximum medical improvement is when your condition plateaus, is when you level off, when you're not going to really be getting any better from treatment. When the doctors are finished is when you've reached MMI. Generally speaking, here in New York State, when it comes to workers' compensation claims, MMI is reached for schedulable injuries. Schedule loss of use and schedulable injuries are extremities, arms, legs, hands, feet, fingers, and toes. Usually, MMI is assessed 1 year after your date of accident or your date of surgery if you have a subsequent surgery. For non-schedulable sites, it's closer to 2 years. Head, neck, and back injuries, usually they look a little bit beyond that and give you a little more time. The purpose of MMI is determining when you're done with your treatment, because it's only at that point that really a fair assessment can be given as to your permanent disability level. So if you went and assessed somebody a week after their accident for permanent disability, number one, you wouldn't know what level of permanent disability they would be at. And number two, you don't know if they'd ever have a permanent disability. Treatment, surgery, things like that. You don't know how much better a person's going to get. So that's generally how MMI works. When you get hurt, you're at the bottom of the barrel. You're as bad as you're going to get. But over time, you're going to get better. Your condition gets better, and then you plateau, you level off. Who determines MMI in your workers' compensation case? And what if the insurance company disagrees with them? That question is kind of leading you to the point that your doctor should be finding MMI. And that's not always the case. I always like when your doctor drives the ship here and tells us when MMI is reached, but sometimes at some point down the road, whether it's 1 year or 2 year or whatever into the case, you might go see an IME, you might go see the insurance company doctor, and their doctor might determine that you've reached maximum medical improvement. Sometimes their assessments are premature. If their doctor finds that you've reached maximum medical improvement here in New York State, what'll happen oftentimes is when the compensation board receives that report, they're going to send a letter out to you and to your lawyer, if you have one, saying, hey, the insurance company doctor has determined that you've reached maximum medical improvement. So what do you want to do? Do you agree with them? Do you disagree with their assessment? Do you want to get your own opinion? What do you want to do? And they give you 60, 75, 90 days to take your own action with respect to that finding. And it helps you direct your case in the direction that you want it to go. So if the insurance company doctor makes a finding of MMI and permanency and you disagree, take that report and go see your doctor and say, hey, doc, this is what their doctor said about me. What do you think? It's kind of like the legal equivalent of fighting fire with fire. They have their doctor's opinions, and I want to know what your doctor has to say so that we can pursue your case in accordance with what you and your doctor have decided to do with respect to your treatment plan. If your doctor finds that you've reached maximum medical improvement first, the insurance company might do the reverse. They might send you out to see their doctor. They might schedule an IME. Sometimes in that circumstance, though, it's a very good time for us to start working on a settlement of your case, because we know what your doctor is saying the case is worth, and we don't yet know what the insurance company doctor is saying, and it could be here and it could be much, much less down the line. So it's a good time for your lawyer and you to start possibly negotiating a settlement of your case, whether it's a Section 32 or a stipulation. So that's generally what happens when a determination of MMI is reached by at least one side in the case. And oftentimes when both sides reach the determination that MMI, there's a difference of opinion there. Your doctor will say one thing and their doctor will say another, and that's when your good old lawyer gets involved and either resolves your case with an agreement or we go to court and we fight it out. What happens when you reach MMI in your workers' compensation case, and what changes can you expect? So when you've reached maximum medical improvement, your case is usually in that, like I said, in that plateau, because there's not much more treatment that's necessary. If your doctor's reaching the conclusion that you're at MMI, he's not going to be requesting therapy or significant forms of treatment. Your case is going to plateau. You're still entitled to symptomatic care, which is the occasional doctor visit or physical therapy visit just to maintain your current level, but your medical care is going to plateau and you're not going to be seeing your doctor as much. When you're reaching that point of maximum medical improvement and your doctor is going to assess you for maximum medical improvement, you need to be super careful. And this is something that if you don't have a lawyer, you're going to trip over this crack in the sidewalk and it's going to be dangerous for you. If your doctor has been determining that you have a temporary total disability, if there hasn't been any determination that you have a partial disability and there's never been litigation, so a judge has never found that you're partially disabled, and your doctor now goes and files a report and says you reach maximum medical improvement, if he finds that you have anything less than a total disability, the insurance company is going to pounce on that. And this is one thing that I really don't like. The Workers' Compensation Board medical form here in New York for determining permanent impairment is what's known as a C4.3 form. It's C-4.3. And on that form, there's a spectrum of exertional abilities, they're called. And it's 5 levels. And there's check boxes: very heavy work, medium work, light work, and sedentary work. And your doctor is supposed to check the box of the work that you're capable of doing. And the problem that I have with that is they're all levels of work. work. There's really nothing there that says that you're totally disabled. So your doctor, almost by instinct, is going to be checking off some level of work that you're capable of and essentially finding that you have a partial disability at that point. And the insurance company is going to pounce on that. They're going to say, you're not totally disabled anymore in the eyes of your doctor. You're partially disabled. And that is going to spark your obligation to look for work. It's called labor market attachment. And you need to navigate those waters very carefully because you want to either avoid that obligation or you want to make sure if you are tagged with that obligation that you handle it properly so you don't get your benefits cut off. You have to maintain attachment to the labor market. You have to continue to look for work within your restrictions until a finding of permanency is made. And this is, we're talking about non-scheduled cases. So if you have a neck, a back, a head injury, once the judge determines that you have a permanent partial disability and makes that conclusion and renders that award, you no longer have that obligation. Once you're deemed to have a permanent partial disability, you don't have to keep looking for work. You want to tiptoe around that very, very carefully because that is a point in time where insurance companies are going to beat on you and try to get your benefits suspended and cause you to lose out on your benefits and your money. So you need to have a good attorney. If you ever have any questions, please give me a call, 212-406-8989. Rex Sikowski. How can MMI, maximum medical improvement, affect your workers' compensation benefits? Which benefits stop and which benefits start? And that's a fantastic question because there is a line there. Once the judge determines you have reached maximum medical improvement, your temporary benefits that you receive while your injuries remain temporary. Temporary means that they're in a state of flux. They should be getting better. You should be improving over time because as you receive more and more treatment, you should be getting better. But if you go and have surgery, you're going to spike back to 100% level of disability and you're going to start getting better again. So your level of disability is going up and down because it's temporary. It's in a state of flux. Once you're found to be at maximum medical improvement, that fluctuation stops. And that's generally when your permanent benefits will kick in. And again, we're talking primarily at this point about non-scheduled cases, but how much you receive and how long you receive them are dependent upon what the finding is as to your level of permanent impairment. And the considerations that the judges use, it's not just a matter of how physically or what your disabilities are, but looking at a case as an example, a back case or a neck and a back case, a judge could say that you have a 50% permanent disability. But on top of that, they're going to consider your vocational background as well, and whether or not your vocational background helps you find work in the future or might hurt you. You might have a very low level of education. You might not read, write, and speak very well. That could impact you. And even though you might have a 50% level of physical disability because of your injuries, your back injury, your vocational background might make you more disabled. And the term we use there is LWEC, loss of wage earning capacity. How much wage earning capacity have you lost as a result of this accident? So the judges look at your injuries and your disabilities, and they also look at your vocational background to come up with your overall loss of wage earning capacity. And that figure tells us how much you get, how long you get it. If you're found to have a 75% loss of wage earning capacity, you're going to get 75% of your compensation rate and you're going to get it for 400 weeks. If you're found to have a 50% loss of wage earning capacity, it gets you benefits for 300 weeks. So you get 50% of the total rate for 300 weeks. So as the more disabled you are, the more money you get and the longer you get it for. What are your rights and options when you reach MMI in your workers' compensation case? And what if you disagree with the doctor's decision? Well, if you disagree with your own doctor's decision, you should have had a better relationship and discussion with your doctor because your doctor should be kind of walking you along. You should see what's happening with your level of disability along the way. And if you feel like you can't walk and you need a wheelchair and the doctor thinks that you're able to run a marathon, certainly there's some issue there. And generally speaking, when you're at the point of permanency, requesting a second opinion is really not something you can do. You can't shop for a doctor's opinion, doctor shopping. You can't do that. If you have a disagreement with your doctor and it's only at the end stage of your case, there's something wrong here. If you have a disagreement in the beginning, if you have a disagreement about treatment, if you don't like their bedside manner, whatever it is, you're free to change doctors. But when you go and change doctors at the very end, just to get a new opinion on your level of disability, it doesn't look very good to the judge. So you don't want to do things like that. Now, you're going to have your doctor's opinion and you're also going to have the insurance company's doctor's opinion. And they don't always see eye to eye. If ultimately the judge rules more in favor of what the insurance company doctor has determined or simply just doesn't give you what you think your case is worth or what your injuries are worth, you can certainly appeal a judge's decision when permanency finding is made. That is something to consider as well. And obviously you want to make sure you speak with your lawyer about that so you know what the rules are and what your chance of success is. Adverse decisions that need to be appealed, the success rate is not fantastic. So you want to go in there with a strong case so you don't have to file an appeal. One other thing to consider here, if your condition worsens. So this does happen, and it happens, I don't want to say frequently or commonly, but it certainly happens from time to time. If your condition worsens, worsens and your case was closed with a finding of a permanent disability, loss of wage earning capacity, schedule loss of use, or you stipulated to any one of those things, you do have the opportunity to reopen the case. Generally, you have 18 years to reopen your case if need be. And if your case was closed by a judge's decision or stipulated agreement between you and the insurance company, you can reopen your case. If you settled your case with a Section 32 settlement, you do not have the opportunity to reopen the case. The only way you can reopen a Section 32 agreement is with the agreement of all parties and the Workers' Compensation Board. And the one small exception here is if you have an indemnity-only Section 32. This is when we close the money side of your case, leave the medical side open. If your condition worsens and you need more care, the care will be there for you, but don't expect more money for it. They settled that, and that ship has sailed. And if anybody has any other questions, please give us a call here, 212-406-8989. My name is Rex Sikofsky. I am your New York workers' compensation attorney. I love each and every one of you. Thank you so much for all your great questions, and have a wonderful rest of your day.